Oh, good.
Good morning. I'm going to call the Police Policy Committee to order. It is August 20th, 2026 at 10:02 a.m. We are at the DPSST conference room. Before we get started, I'll read the Police Policy Committee administrative announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. Next, we'll go with introductions of members, staff, and guests.
When calling you, please state your name and who you represent for the record. Start with you, Chair Nowling.
Scotty Nowning, Salem Police, non-management law enforcement.
Vice Chair Cotting.
Casey Cotting, Oregon State Police.
Amber Livingston.
Major Teresa Livingston, Oregon State Police Command Staff.
Mine, we have Member Sarek.
Anel Sarek, Washington Sheriff's Office, non-management law enforcement.
Thank you. Member Hughes.
Deputy Chief Brian Hughes, Portland Police Bureau.
And then online as well, we have Member Hensman.
Chief Warren Hensman, Oregon Association of Chiefs of Police.
Thank you. Member Lofgren.
Patty Lofgren, public member.
Tim Willits, non-management law enforcement, Silverton Police.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Erica Riddell, DPSST.
Melissa Langbacho, DPSST.
JC Gamble, DPSST.
Phil Castle, DPSST.
Maria Atwood, DPSST.
Jennifer Howell, DPSST.
Sam Penny, DPSST.
Victor Sanchez, DPSST.
And Cindy Park, DPSST.
Back to you, Chair.
Thank you. Next, the committee needs to approve the previous minute meetings. There were two on May 21st, 2026 and June 23rd, 2026. Did everyone have a chance to review? And any changes or modifications that are needed? Speak up now. If not, I'm looking for a thumbs up consensus to approve the meeting minutes as is. Any objections? Hearing none, they're approved. Next, we'll move to the administrative closure consent agenda. And professional standards case manager. Thanks.
Melissa Langbacho for the record. The department reviewed 3 cases and is recommending administrative closure in those cases. They're on a consent agenda for the committee's consideration today. The department is seeking a vote from the committee to approve or return the cases for further consideration. Chair.
Thank you. If there's no questions, we'll be looking for a motion and a second to approve the consent agenda as it was presented in our material.
I will make a motion to approve the consent agenda.
Willits, all second.
We are voting on a motion to approve the administrative closures. Chair Nowning.
Aye.
Vice Chair Cotting.
Aye.
Committee Member Sarek.
Aye.
Committee Member Hughes.
Aye.
Committee Member Hensman.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
And Committee Member Willis. Motion passed.
Thank you. Next, we'll have Professional Standards Division Director Marie Atwood make a quick statement.
Thank you all. We're about to move into the professional standards cases for your review today. Just by way of the record, I want to note that there is a case on today's docket that involves a former member of this committee and of our board on professional standards that many of you may have worked with in those capacities. All of our members of all of our committees and our board are trained on conflicts of interest. But if anyone believes that they cannot decide this case in a fair and impartial manner for any reason at all, please note that for the record and feel free to recuse yourself. If no one feels a conflict of interest is present, we can move ahead with the professional standards case agenda.
Thank you. And so we will move to the professional standards case review. We have 3 individuals and they're all 3 here. Is that correct? Okay. Gonna bring, I think we're starting with
Okay,
Douglas
Kitzmiller.
Kitzmiller.
Yeah.
That was an awkward pause. Wrote it. Write it down. Awkward pause.
Seeing if you're awake.
It's like somebody gonna do something, but I didn't know what to do with my hands.
You got that reference.
That'd be cute. Good morning. Thank you for being here. My name is Scotty Nowning. I'm the Chair of the Police Policy Committee. We'll begin your case by first hearing a case summary from DPSST. Then I will give you further instructions before you begin your statement.
Chair, Melissa Lingato for the record. The department opened a professional standards case to review Douglas Kitzmiller's separation from the Canby Police Department and his reported criminal charges for trespassing and unlawful use of a thermal camera. Criminal charges stem from an incident in November 2024 after a citizen reported to the Oregon State Police hunters were using thermal devices to locate game animals in the Sanium hunting unit. OSP reporting indicated that Kitzmiller was depicted in the videos using thermal devices to scan the area and locate animal heat signatures, and then using a spotting scope and binoculars to pick out details. Kitzmiller held a valid permit to access the private property, which he was hunting, but permit holders were restricted to specific times of the day. Kitzmiller was observed on trail cameras and license plate readers set up earlier in the year by the state police to be in the area at times when he is not authorized to be on the property. The Oregon State Police obtained a search warrant for Kitzmiller's home to seize his phone and 2 thermal imaging devices. Kitzmiller, while escorted by an OSP lieutenant, retrieved one of the thermal devices from a backpack in his room in his home. The lieutenant asked Kitzmiller about a second thermal device, and Kitzmiller told the officer, "I do not have a second one, and that isn't mine." After he was shown a video of himself using a larger thermal device, Kitzmiller retrieved the keys to his work vehicle and a larger thermal device from the passenger glove box and turned it over to the state police. He was charged with unlawful use of a thermal camera and criminal trespass in the 2nd degree. He pled guilty and was convicted on charges for unlawful use of a thermal camera, and the trespassing charge was dismissed as part of a plea agreement. His employer had placed him on leave while the state police were investigating the incident, and no internal investigation was conducted after he resigned. The department reviewed information in the records and found conduct that violated the board's moral fitness standards. And for each of the categories, the department identified for dishonesty that Kitzmiller was intentionally dishonest by omission when he initially only provided 1 thermal device to the state police during a search warrant and stated he did not have a second thermal device. For misuse of authority, Kitzmiller intentionally utilized his position for his benefit when he used Canby's thermal device for his personal use. And for misconduct, Kitzmiller violated criminal law and has a misdemeanor conviction for unlawful use of a thermal camera. Kitzmiller created an inefficient operation of the Canby Police Department when the thermal camera belonging to the Canby Police was seized as part of Kitzmiller's criminal investigation and prosecution. The department is seeking a disposition in the case from the committee. Mr. Kitzmiller provided written mitigation that was provided to the committee and is here to provide a statement today, Mr. Chair.
Thank you. This is the time to make your statement. You'll have 5 minutes to share any information you would like for the committee members to consider during the deliberation of your case. Your time will be monitored on the clock, located right in front of you here. And at the conclusion of your statement, you may choose to remain in the room, but you will not be permitted to ask questions or provide additional comments for the case.
Good morning, members of the Policy Committee. Thank you for taking the time to review my case and for allowing me the opportunity to address you today. First and foremost, I want to apologize. Nearly 28 years ago, I took an oath to serve the citizens of Oregon and uphold the law. As a police officer, a supervisor, and ultimately a police captain, I understood that I was held to a higher standard than most citizens. In November of 2024, I failed to meet that standard. I accepted responsibility by pleading guilty to the criminal offense and have fully complied with every condition imposed by the court. More importantly, I accepted responsibility for disappointing my profession, my department, my fellow officers, my family, and the public I served. The hardest part of this process has been knowing that in this instance, I failed to live up to the very standards I spent my career asking others to meet. One thing I hope this committee understands is that accepting responsibility has not diminished my respect for this profession. If anything, it's strengthened it. I still believe that law enforcement is one of the most honorable and noble professions a person can choose. I believe that throughout my career, and I still believe it strongly today. Although I no longer wear a badge, I haven't walked away from this profession. Since leaving the Canby Police Department, I became an adjunct instructor at the Chemeketa Community College in their criminal justice program, and I've had the privilege of helping educate and prepare future law enforcement officers. That opportunity means more to me than I can adequately express because I still believe in serving this profession. I hope that I can continue earning the opportunity to contribute by not only sharing the knowledge and experience I gained through nearly 3 decades of law enforcement, but also some of the difficult lessons I've learned from my own mistakes along the way. Any good can come from the decisions that brought me here today. I hope that my experience can help other officers avoid making similar decisions in their future. I know this committee's responsibility is not to reward a long career. Your responsibility is to protect the integrity of Oregon law enforcement and maintain the public's confidence in our profession. I respect that responsibility. Not asking you to excuse my conduct or overlook my conviction. I'm simply asking that in reaching your decision, you consider the totality of my career and the entirety of the record before you. For nearly 28 years, I devoted my career to serving the citizens of Canby, mentoring officers, managing critical incidents, teaching, and trying every day to leave this profession better than I found it. I hope that my record, together with my acceptance of responsibility, my genuine remorse, and my continued commitment to serving the law enforcement community will be weighed alongside the decisions that brought me here today. I respectfully ask that you carefully weigh the significant mitigating factors outlined in my written response, including the factual inaccuracy identified in the draft report and the conclusions that I don't believe are supported by the record. I also ask that you give appropriate weight to the letters of support submitted on my behalf by respected leaders in the law enforcement community who worked with me and supervised me throughout my career. After reviewing the full record, I respectfully ask that you reach a decision that is fair, proportionate, and consistent with the evidence in front of you. Thank you for your time, your service to this profession, and your thoughtful consideration. Thank you.
Thank you. We'll now be looking for the committee to adopt the record as presented or amended. Just looking for a consensus to adopt the record as presented. We didn't make any amendments.
You want a motion or a thumbs up?
It's just a consensus. Okay. So, sorry. Any objections? Hearing none, we'll adopt the record as presented. We'll now discuss aggravating or mitigating factors. Reminder to state your name for the record and identify if the point you're bringing up is an aggravating or mitigating factor.
Livingston for the record, mitigating. One, I did watch the video and then the correction in what he said on this isn't mine. And it's this, that's mine. I felt like the way I heard it is he was saying that the one he was handing over at the time in there was saying that that was his. The other is his statement today is very compelling and taking full ownership of his actions and how he clearly understands the brevity of how that is seen on the community, law enforcement community and the impact. And I think that he was very humble and genuine in his statement today.
Thank you.
Ivy Lockburn, public member for the record. Mitigating were, to me, the two very strong letters of support from two former chiefs of police.
Conning for the record, can I ask a clarifying question? When we adopted the record, did we bypass any discussion or option to negate any of the moral fitness violations, or is that?
Not yet.
Not yet.
Yeah.
That's coming ahead. Okay. Or to adjust the language or.
Right, that would be the next step.
Other aggravating, mitigating?
Bullets for the record, I'll throw out them for mitigating. I feel like his service to the community and his long career without any punishments is mitigating.
Online, any comments?
Connie, I'll add to the record for mitigating that this is a relatively new tool or practice within the hunting community. I think there's some confusion amongst hunters, and the education piece is ongoing with appropriate use of thermal devices.
Any other comments before we review them? Well, Melissa's writing, so we'll pause.
Um,
No hurry. Whenever.
Melissa Lane Botcher for the record. I heard only mitigating circumstances, that there was a corrective statement that he made when talking about the thermal devices in the body worn camera video. His mitigation was mitigating, and he provided a humble statement to the community. He has the support from the community and a long history of professional services. The thermal device is a new tool in the hunting community, and education on appropriate use is still ongoing, Mr. Chair.
Looking for a consensus that she captured everything and that is now part of the record by thumbs up. Okay, we have a consensus. We'll now begin deliberations regarding the moral fitness violation categories identified in the staff report. The moral fitness categories, which were identified in this one, were all three: dishonesty, misuse of authority, and misconduct. Correct. After discussion, we will need to vote to affirm, modify, or negate violations alleged. And I think just to throw in, I believe if we, I'll wait actually to see if we take action on the date. So we'll look for discussion, deliberations on the moral fitness violation categories identified.
Deputy Chief Hughes, I'll start.
Oh.
I'd like to address the dishonesty component of the moral fitness review and highlight that during the investigation, Captain Kitzmiller did assert his right to speak with an attorney, which is his right to do. And however, continued to be asked questions about the thing. And so even in the discussion between the investigators, you hear some discussions about how to properly navigate that. And I think they were doing him a professional courtesy by having the additional conversation about the other thermal camera so that they didn't have to get into, searching the entire residence for that. Certainly, I don't know. I didn't read the warrant to see whether or not the captain's work vehicle was covered in that. I tend to think it may not have been covered in the search warrant. Either way, I think Captain Kitzmiller did the right thing, corrected the path that was going down, and ultimately provided that second thermal imaging device. When it comes to the first thermal imaging device and claiming the discussion around that's mine, I agree. I think that he was accurate in stating that. There's no further penalty at that point for using two thermal imaging devices out at the scene. There may be some question later on about where that other thermal imaging device came from, but initially, no reason to believe that was dishonest on his part. So for me, I negate that part of the moral fitness. I believe it should be negated, the dishonesty side of the moral fitness standard.
Scotty Downing, for the record, I would agree with everything you said, and it's a very nuanced, I know when we hear of untruthfulness and you're talking about dishonesty, that could potentially bar someone for life. I think, this committee has heard a lot of dishonest, testimony before us, and this is far more nuanced, I think. And it's a little bit splitting hairs on whether it was an actual lie or, just answering the question bluntly, like, this is mine. The other one was not mine. And so I would second that sentiment to negate that dishonesty. And open to hear other questions about or comments about that part of it, at least. And then there's two more moral fitness violation categories we also have to discuss. I mean, I'll add, I think the misconduct is by his own admission. He was doing something he wasn't supposed to be doing. He pled guilty, which did accept responsibility. So that moral violation to me is fairly straightforward.
I agree, Deputy Chief Hughes. I agree with that sentiment as well, that the misconduct is clear. That ship has already sailed, in my opinion. And we can discuss maybe a little bit more about how that should be handled. But the misuse of authority, I'll jump into that one. I don't believe that was intentionally utilized the position for his benefit when he used the thermal device for personal use. I mean, he had a thermal device already, whether or not he had 2 thermal devices or 10, he already had one. And as Superintendent Conning mentioned, this is a relatively new technology to the industry. We're still kind of wrapping our heads around that, but Captain Kitzmiller's end result in this and resolving the criminal case leads me to believe that, that the lesson had been learned, and it's clear as day now. I'd also like to highlight that Captain Kitzmiller continuing on in his role in an educational fashion to continue to support the profession. That's a very indirect way to support the profession. Those are people that are coming into this profession moving forward. He's taking his, I thought it was 30-year career and using that for the greater good of our profession. So I think for me, the settling the misconduct thing resolves the moral fitness aspects of things. So I would negate the misuse of authority as well, is what I'm trying to say.
Stand for the record, I second.
Oh, you're making a motion.
Oh, he said he,
Oh, are you making a motion to?
I thought he was.
Okay, let's hold off 1 second to make sure that everyone had a chance to discuss. I want to make sure we establish a really good record. So
Still in discussion mode. Sorry, Major.
His discussion, you're right though. His discussion was a motion. I was catching that too. But I do want to make sure that everyone has a chance to be heard and we get everything on the record once we said.
Back into discussion.
Chair, if I could, Warren Hensman, for the record. I just wanted to, and I agree with the conversation. Something that stood out to me as I watched the video, for a law enforcement professional of 28 years, and certainly shocked when the OSP shows up at your door. His spouse was supportive. I think he acted incredibly appropriate. But the one thing that stood out was when he was questioned about that second device. And you can clearly see his eyes looking directly at his work vehicle if you watch the video back. And he's processing. I think we have to recognize people deserve time to process what's going on. And I think he processed appropriately. And I would just agree with everything that was said here today.
Thank you. Any other discussion? So we'll be looking for motion. Sounds like Mr. Chief Hughes has.
Yeah, I'll
motion.
start by making a motion to negate the dishonesty aspect of the moral fitness part of this. Is that appropriate? Did I say it right?
How about this? I'll make a motion that we affirm the misconduct and negate misuse of authority and dishonesty. Can we do all three of those in one?
I second.
We can do all three of those. Okay. Thank you.
We are voting on a motion to modify the moral fitness violations to remove dishonesty and misuse of authority and affirm misconduct. Chair Downing,
Aye.
Vice Chair Cotting.
Aye.
Committee Member Sarek.
Aye.
Committee Member Hughes.
Aye.
Committee Member Hensman.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
And Committee Member Willetts. Motion passed.
Now we're need a motion and a second to take action or not take action. Please state your name for the record and your supporting reasons to take action or no action.
Livingston, for the record, I would actually like to vote to take no action. I feel like, he's, with everything that he's taken responsibility and owned it, and to the degree in which he did, I think that he certainly has, learned the lesson and taken his his consequences for it. And I think that that's enough in my mind, and thinking about past decisions and cases that we've had. I vote for no action.
I would second that.
All right, we are voting on a motion to take no action. Chair Downing,
Aye.
Vice Chair Cotting.
Aye.
Committee Member Sarek.
Aye.
Committee Member Hughes.
Aye.
Committee Member Henson.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
And Committee Member Willetts. Motion passed.
Thank you. Terry Rowan will be our next case. He's also in person. No, it's just a game. No, it's just a game. It's the other time. It's fun. Good morning.
Morning.
My name is Scotty Nowning. I'm the chair of the Police Policy Committee. We'll begin your case by first hearing a case summary from DPSST. Then I will give you further instructions before you begin your statement.
Chair, Melissa Lingbottom for the record. The department opened a professional standards case to review Terry Rowan's self-reported arrest and criminal citations for reckless driving and driving under the influence of intoxicants. Rowan was stopped by officers from the Gillum County Sheriff's Office after 911 dispatchers received reports of a driver swerving, driving down the middle of the highway and speeding and nearly crashing. Rowan, who was driving a county vehicle, was observed by the sergeant to have glossy eyes and was concerned that Rowan was intoxicated. Rowan told the sergeant that he had no alcohol that day and that he was completely sober, but had injured his back while playing golf. Rowan participated in field sobriety testing, which indicated that Rowan was under the influence of intoxicants. When he was told by the sergeant that they could smell the odor of alcohol coming from him, Rowan stated that I have not had any alcohol. Rowan was transported to a regional office for a breath sample, which reflected 0.19 blood alcohol content. Rowan was charged with reckless driving and driving under the influence of intoxicants. He entered a plea of no contest for both charges and was granted diversion. He's completed diversion for both of the charges, which have now been dismissed. The no contest plea for reckless driving and DUI meet the definition for criminal disposition in the administrative rule. The department identified conduct in the record that violated the board's moral fitness standards, identifying dishonesty, that Rowan was intentionally dishonest when he stated he was completely sober while he had a BAC of 0.19%. For misuse of authority, Rowan's use of the county vehicle to drive home while intoxicated was an intentional misuse of his position for his benefit or to avoid the detriment of arranging an alternative way home. For misconduct, Rowan violated criminal law and has criminal dispositions based on his plea of no contest for reckless driving and driving under the influence of intoxicants. Rowan's intoxication while operating a vehicle in a reckless manner threatened persons and property. Rowan's arrest, driving while intoxicated in a county-owned vehicle, extended absence to complete the terms of his court order, and negative press related to his criminal charges impacted the credibility and efficient operation of the Umatilla County Sheriff's Office. The department is seeking a disposition in the case from the committee, and Rowan provided written mitigation, some of which was provided yesterday, that was given to the committee, and he's here today to provide a verbal statement. Mr. Chair.
Thank you. This is your time to make a statement. You'll have 5 minutes to share any information you'd like for the committee members to consider during the deliberation of your case. Your time will be monitored on the clock, which is located right in front of you there. And at the conclusion of your statement, you may choose to remain in the room, but you will not be permitted to ask questions or provide additional comments for this case. As soon as the clock is ready, you can begin.
Thank you. Chair, committee members, I come before you today with humility and profound regret for the actions that brought me here. I offer my sincere and heartfelt apology to the committee. I'm deeply ashamed that my actions and poor decisions have brought me before you. I have always held this committee in the highest regard, making these circumstances especially difficult. I would like to address some points in the staff report. The statements I made that evening that I was sober and not consumed alcohol were inaccurate and inconsistent with my actual condition. Those statements were not part of a calculated, intentional effort to mislead the officers or avoid accountability. I acknowledge that my use of Zen also delayed the breath testing process. I did not do that to delete, manipulate, or invalidate the test, and I did provide the requested breath sample. My use of the emergency lights was consistent with my customary practice of alerting officers for safety during a roadside interaction. I did not do so to resist a stop, assert jurisdiction, intimidate the sergeant, or signal that I expected professional courtesy. I recognize that the action could have been misunderstood, but it is not intended as an invocation of my authority or a request for different treatment. I was driving my regularly assigned unmarked county vehicle, which I use daily in carrying out my responsibilities as sheriff. And I was returning from home from a law enforcement conference. As for the allegations of DUI and reckless driving, I take full responsibility for my actions, and I have complied with all obligations imposed by the court. Shortly after the incident, I issued a public statement and a letter to the men and women of the sheriff's office. I also spoke personally with the commissioners. In all of my communications, I've accepted full responsibility for my actions because I believe transparency and accountability are essential. Throughout my career, I expected those standards for those I had the privilege of leading, and it was equally important that I held myself to them. While I cannot change what happened, I have taken meaningful steps to ensure it never happens again. Shortly afterward, I entered into and completed an inpatient treatment program designed for first responders. After completing that program, I continued with counseling, weekly meetings, and recovery support to understand the issues and unhealthy patterns that led me to that night. This work has required me to confront painful truths about myself and make meaningful changes in how I live, respond to stress, and ask for help. I remain committed to this work because I never want my actions to place another person, my family, my profession, or my community into this position again. Throughout my 37 years of public service, I've maintained a strong professional record. and took seriously the responsibilities expected of me. During this difficult period, our office earned state accreditation for law enforcement and 911 communications through the Northwest Accreditation Alliance, building upon the 2024 accreditation from the Oregon State Sheriff's Association for our jail. These independent evaluations reflect the professionalism of our employees and the office's continued commitment to accountability, transparency, and effective service. As sheriff, I work to strengthen the culture of the sheriff's office and helped establish wellness initiatives, peer support teams, a chaplaincy program, yet while encouraging others to seek help, I failed to fully recognize and adequately address my own need for help. My years of service do not erase what I did, and I do not offer them to excuse or minimize my conduct. I cannot undo my actions or the harm they cause. I can only continue taking responsibility, living differently, and doing the work essential and necessary to become a better man and public servant. I respectfully ask you to consider my entire career, my acceptance of responsibility, the work I have done since that time, and the meaningful changes I've made in my life. I do not ask the committee to minimize my poor decisions. I respectfully ask the committee to distinguish that conduct from a calculated effort to deceive officers or intentionally use my office to obtain special treatment, to consider my complete record, treatment, accountability, recovery, and low risk of reoccurrence when deciding whether certification action is necessary. I am deeply sorry. My actions and harm they caused. Thank you for the opportunity to speak.
Thank you. Now ask the committee to adopt the record as presented. Consensus, thumbs up. We do have a consensus, no objections. Hearing none, the record is adopted. We'll now begin discussion of aggravating or mitigating factors. Reminder to state your name for the record. Identify if your point is an aggravating or mitigating factor.
Deputy Chief Brian Hughes for the record, a mitigating factor. I'm very familiar with the diversion process and the steps that people take during that, as well as the lessons learned from that. It tends to be kind of a one and done, I think, for most people. They go through it, they're forced to it by the court. And I think that happened here. I think that the sheriff was forced to it by the court. But what I saw in here, and reading the additional materials that were provided, and hopefully everybody else did, I'd like to highlight a letter that was written by a member of the Oregon State Bar, who is Sheriff Rowan's sponsor. And in that letter, the sponsor talks about ongoing work in this program. And I haven't always seen that during my time in this profession and involved in the recovery world. So to see Sheriff Rowan take that next step, and it appears to me to take it very seriously, I believe, as a mitigating factor.
Thank you.
Sam Mills for the record. While I find his BAC to be aggravating, I do find his work for recovery to be mitigating. I think the fact that he sought out a treatment program specifically for first responders to deal with the stress and the root cause behind what he was facing that day, I find that to be very mitigating, because I think oftentimes we as first responders are kind of drawn to help other people and we put ourselves second. So
Got it down to the record. Aggravating, obviously, he was in a county-owned vehicle and multiple phone calls were made about his driving, so it was clearly high BAC. A 0.19 was having an effect on his driving, which was concerning enough to have members of the public calling him in. And he's in a county vehicle, so it's obviously aggravating factor.
Counting from the record, aggravating, obviously the level of impairment is very dangerous to the motoring public and to the sheriff. And on top of that, you add high speed above 90 miles per hour and failure to maintain lane and nearly striking a guardrail. They're all aggravating in the seriousness of the actions taken that day. It is mitigating, I'll add, the level of support that has been written and conveyed to us is there is a lot aggravating. There's also, I think a fair amount of non-support that isn't in the record, but is aggravating that we're discussing multiple aspects of the conduct that day, and one is inaccurate statements on more than one occasion. So after time to reflect at the level of seriousness of the situation with law enforcement, regardless of rank, there's continued inaccurate statements about his alcohol consumption that led to the ultimate arrest. So it is mitigating today that that was acknowledged. I had not seen that prior to today, and I appreciate the fact it was mentioned to the committee.
Additional aggravating, Scotty Downey for the record, is, just the position he puts the deputy in who pulls him over, turns on his lights, and now it's the sheriff of another county. And it's just it's a tough position for a law enforcement subordinate rank to be in, to be facing a sheriff of another county and continue to do the right thing. And so, we've seen officers before this committee who've not done the right thing, and it puts them in a position where their career is potentially in peril. So I just think the fact that he made these decisions that put not only the motoring public, but his fellow police officers in, a really tough position is aggravating.
Warren Hensman, for the record, just to join in the aggravating and mitigating piece. The speed piece for me, when he did not know he was going, I believe it was 91 miles an hour versus I set my cruise control at 71. I think that's the statement that was made. That's aggravating because of the severity of the circumstances surrounding a DUI of this nature. And then, of course, the mitigating is the service. Almost 4 decades of service cannot go unspoken to.
Any further discussion of aggravating, mitigating? Or Melissa recaps?
Celine Botcher for the record. I heard as mitigating the diversion process and the opportunities provided in that gave the sheriff opportunity for lessons learned, and he's not likely to repeat the offense again. His sponsor provided a letter of support that was impactful, and he's taken the process seriously. His work towards recovery is mitigating, and he sought specialized treatment for first responders. The mitigation that was provided to the committee was substantial and significant. And he has almost 4 decades of service in law enforcement. For aggravating, I heard his high content county vehicle. There were multiple reports to 911. The level of impairment presented a danger to the public and the sheriff himself. His driving was aggravating to the situation and was serious. In his statements to the officers, there were continued inaccurate statements that he provided. His actions put subordinate deputies from another agency in an uncomfortable position where their career might be on the line. And his speed, he indicated that he did not know that he was going 90 miles per hour and stated that he set the speed control at 70 miles. So all of the items that I heard, Mr. Chair.
Thank you.
Livingston, for the record, can I add one?
Of course.
For aggravating, oftentimes when we sit here and listen, we hear about mitigating, about the amount of years of service that people give to law enforcement, which I don't think should be discounted, and I absolutely agree that that can be mitigating. But in a lot of cases as well, it could be looked at as an aggravating when you have that level of experience and time on the job, and the level of accountability and responsibility you have or knowledge in that should be also identified as you absolutely should know better on every single element that we discussed today, with 40 years of experience.
Thank you. I'll just have you recap.
That one.
Thank you.
The years of service can be mitigating, but also in the circumstances an aggravating circumstance because he should have known what he was doing was not correct.
Thank you.
Connie, I'll add, aggravating is relating to the dishonesty component of this or inaccurate statements. Law enforcement is a profession where the credibility and honesty of an officer is scrutinized at many different levels. And in this case, I think the record clearly shows that it was inaccurate. And, the level of dishonesty and what the purpose was, obviously there's impairment, but it's aggravating that someone in this profession doesn't understand that regardless of impairment and the level of seriousness that brings.
I have as an additional factor is aggravating that credibility for law enforcement is scrutinized at multiple levels, and there was dishonesty at multiple times, regardless of the level of impairment that was present, which is serious for a law enforcement officer.
Thank you, Melissa. Looking for a thumbs up consensus to accept the identified factors as Melissa has outlined. We have a consensus. Next, we'll do deliberations regarding the moral fitness violation categories identified in the staff report. In this one, all three: dishonesty, misuse of authority, and misconduct were identified. And then after discussion, we'll need to vote, affirm, modify, or negate the violations. And if we could, I'd like to have all the discussion and then we'll make a motion after a robust discussion. I'll start. Scott Downing for the record. I believe all three categories, dishonesty, misuse of authority, and misconduct, are fairly plainly laid out in the staff report and the evidence that was presented to the committee, and a lot of the things we talked about during the mitigating and aggravating, the use of a county vehicle, his untruthful or dishonest statements about his level of intoxication or whether he had drank at all. And then obviously the misconduct, he had accepted responsibility for the reckless driving and the DUI.
Deputy Chief Brian Hughes for the record. The misuse of authority aspects of this, as I was looking through and reading, I don't think that Sheriff Rowan would have made any different decisions had it been his personal vehicle there. I've taken, personal vehicle and a work vehicle on many training seminars throughout my career, and have not been presented with this, but this choice. But given the nature of where this case ended up, with inpatient continuing to work a 12-step program, clearly there was a problem there. And I think that the misuse of authority, like I said, I think either way, based on what I know about addiction and where Sheriff Rowan appears to be in this process, I think that he would have taken his personal car either way. So I don't find that, I just not making the connection for misuse in his position for a benefit. The lights were turned on when he was pulled over. I'll acknowledge that. I, it's, I also hear what Sheriff Rowan says when it's just a natural, when you're on the side of the road and, turning on the lights is something that we do. It's part of what you do. When you're in the county vehicle, you turn on the lights and, that could be either way. But for me, the preponderance of the evidence was more towards just turning them on to avoid being a hazard on the side of the road. So I'm having a difficult time with the misuse of authority aspects of this.
Samuel, let's all add to that. I think I agree with the lights. I think that was just kind of a common courtesy thing. I think he was just trying to identify himself as a law enforcement officer. I don't agree with the vehicle part. I think that if I take a publicly owned vehicle to training, I'm very cautious about what I do in it and how fast I go and just anything that revolves around that vehicle. So I think that while I don't have one that's unmarked and assigned to me that I take home every day, and maybe that comes with a little bit of just complacency, I think that misuse of authority is there.
I guess I'd offer in response, I'm sorry, Deputy Chief Brian Hughes for the record. In response to that and a little more discussion on the misuse of authority, I do have a take-home car and subject to 24-hour callback and often am in it just for fear. I see the city of Portland there behind me and never know what this city's going to throw at me. And so I always need to be ready to come in. And I guess in that light, if, at what degree? I mean, we're talking a very serious degree here. We're talking as Superintendent Connie mentioned, high speeds on the freeway, 91 miles an hour. That's dangerous. Failing to maintain a lane while passing commercial motor vehicles, all completely dangerous. This is a very high level thing that we're talking about here. But, on the way I can think of today, just coming back from shop with a cop, going over the lane divider, as I was looking at my GPS, trying to reroute traffic to get into work, and technically going over the center lane divider is a traffic violation. And I'm not certainly misusing my authority to drive the car to work today and go over the line. But they're two extreme different things. I just want to point out that there are different levels there, and it just doesn't seem to me that he intentionally used his car to potentially avoid getting a DUI. I mean, he's a sheriff, is going to take the car to a training conference. And in my role as deputy chief, I'm going to take my car to a training conference. So it's something I just always do. So for me, it was, again, not as much on the misuse of authority side as a tool that he has regular access to. And certainly not negating the poor decisions that were made. They're clear as day to me, but misuse of authority, I'm having a difficult time getting there still.
I think I'll add to the record on that, but for his position and the fact he was at a conference, it was well within his job description to be doing. He would have probably likely been in a personal vehicle. I think the conduct would have occurred either way. I don't know that, the fact he's in the county vehicle, poor choice, probably against county policy and other things that are outside of this committee, but the benefit of the authority, I don't know if I see that either. And today's testimony on the lights being applied, I find that mitigating. And I thought the sheriff's description of naturally turning them on when you pull to the side of an interstate with high speed vehicles is within normal parameters. So.
Scotty, and for the record, I guess to make the leap to misuse of authority after hearing yours, it would have to be his mindset was like, hey, I'm intoxicated, but I'm going to drive home because I'm in a police car and I'm probably not going to get stopped, or if I do get stopped, I'm going to be fine. We would have to make that leap, and I don't know that I could do it. So I think you guys probably talk to me maybe more into your side of I just don't have the evidence that was his mindset, that he was going to be able to get away with it. And I think if that was his mindset, then I would absolutely say he was misusing his authority because he has a police card. So he can do things that maybe some other folks couldn't get away with. Did that make sense?
Livingston for the record. I think too, and this is kind of a funny way to lay it out, but his level of impairment was extremely high. And so when you're in that high level of impairment, you're gonna do things that are just kind of like natural. And he's in his car and like he described, like he's gonna do something he does all the time without even giving it any thought. And then he is in those particular actions. I agree with you. I just don't think there's the intent on the misuse of his authority on that. I just think it was just the totality. I'm struggling with that one as well.
Yeah, Warren Hensman, for the record, I would agree. I'm struggling with the misuse also. It almost feel, although this is not an Oregon law, but it almost feels like it's a enhancement type of a crime, essentially, you know, public official driving drunk in a squad car. I mean, that's kind of where my head goes. So I would agree with the conversation regarding the misuse of the vehicle. In my mind, it just elevates the misconduct.
Thank you. I think that clarifies it. It would move it, not to say that it's okay that he did it, but
Yeah.
move it to misconduct instead of misuse of authority.
Patty Lofgren, for the record, I was gonna say the same thing. It seems very much to me like it falls under misconduct rather than misuse of authority. That feels like it's taking it to a level that I'm just not seeing.
Thank you.
Sam Willis, I think I follow you now, and I think that your strange way of putting it is followed it very well. So I've been swayed.
Brian Hughes for the record. Can we get into some discussion, or I'd like to get into some discussion around the dishonesty aspects of this moral fitness violation? I've not been privy to many of these cases. This is only my second hearing, so I'm not sure of how the committee has looked at these previously, but I would just like to highlight that the record indicates to me, as I've said before, that Sheriff Rowan clearly had a problem with alcohol, has a problem with alcohol, because you never will not have a problem with alcohol once you do, and has taken steps, I think, in a positive way to address that. But one of the issues that comes with this level of addiction and a high BAC are two things. It's one, the high BAC, as Major pointed out, impairing judgment and potentially saying things that you wouldn't normally say, or do things that you wouldn't normally do. I have nothing in the record that indicates Sheriff Rowan typically drives 91 miles an hour around Umatilla County, and that maybe that this could be a time when that happened due to impaired judgment. But when it comes to intentionally dishonest, I think Sheriff Rowan's behavior, especially as a law enforcement professional and in the business, he should have known better. I think it's more reckless than intentional when it comes to the statement of being completely sober. And that's what the violation is highlighted here for me, that he stated he was completely sober and had a BAC of 0.19. For an alcoholic person, it can be dangerous to have a low BAC, and they may frequently be at a high BAC. I don't know, and there's nothing in the record to indicate that. I'm just saying from personal experience with people that I'm familiar with, somebody may not feel very impaired at a 0.19. That is a possibility here. So I don't know how the committee has looked at this before. I'm not trying to justify what happened there. Clearly, he spoke things that were untrue and has now come back to correct that record, which indicates to me an all-around awareness that what was said and what happened at that traffic stop was untrue with how he portrayed himself in his level of impairment and not having drank. The not having drank part is not included in there, but I'm assuming we can still talk about that. So I don't know if this is a point for discussion. How have we looked at this drug impairing a person's ability or decision making and judgment in the past? Am I allowed to ask those questions?
Yeah, we'll let Director Atwood address it first.
Thank you. Marie Atwood for the record. I just want to clarify for purposes of determining whether violations exist, the alleged violations are based on the conduct that occurred at that time. So while mitigating circumstances may impact the committee's decision on, for example, what to do with an ineligibility period, mitigating circumstances that have happened since the time of the conduct shouldn't factor into whether the conduct occurred. Hopefully that's helpful. So in this case, the conduct that we referenced when detailing the dishonesty violation in the staff report was the particular statement that Sheriff Rowan made, indicating he was completely sober, had had nothing to drink, and was nevertheless at a 0.19% during this event.
And Livingston, for the record, and I just not sure because you just have that one sentence, but if you also listen to the audio from the body worn camera in the intoxilizer, he's asked a direct question. So you haven't had anything to drink today, and he said no. So it wasn't about level of impairment or if he felt sober or not sober. He was specifically asked, so you didn't have anything to drink today, and he said no. So I don't know if we can consider that in part of the dishonesty, because it's not like listed. I just
we have it in our
clarify.
material.
You can, yes.
Okay.
Anything that was in our material, we can consider. Yeah, maybe when we get to the next step, I could talk more about what I was going to say. But so we're looking for a motion to affirm, modify, or negate violations. And I would make a motion that we affirm dishonesty and misconduct and negate misuse of authority.
Winston, for a second.
All right, we are voting on a motion to modify the moral fitness violations to remove misuse of authority and affirm dishonesty and misconduct. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Sarek?
Aye.
Committee Member Hughes?
Aye.
Committee Member Hensman?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
And Committee Member Willetts. Motion passed.
Okay, we're now calling for a motion and a second to take action or take no action. Remember to state your name and your supporting reasons for taking action or not taking action.
Coming for the record, I would propose we take action. And largely, for me, the factors of the misconduct and then the details surrounding the dishonesty that have been put on the record sway me in that direction.
Scotty Downing, for the record, I would second that for the exact same reasons.
All right, we are voting on a motion to take action. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Sarek? Committee Member Hughes?
Aye.
Committee Member Hensman?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
And Committee Member Willetts. Motion passed.
We'll now move to the discussion of the ineligibility period. And we'll have the case manager clarify when the start of the ineligibility period would be before we start a discussion.
The sheriff is still employed, and under those circumstances, I believe it would be based on the date of the board's review, which is in October.
So we will now have a discussion on the motion, and we need a motion for ineligibility period. Remember to state your name and for the record, and also the reasoning for your proposed ineligibility period. We have dishonesty, which is 3 years to a lifetime, misconduct, 3 to 10 years. We are between 3 years to lifetime. I guess I'll just speak a little bit to Chief Hughes. This board has heard many of these type of cases. We've had people just flat out be untruthful during DUI, and the board has acted in the same way this committee did, as far as finding that they were not truthful. And then we've also had people before us who were very honest during the whole process, and we did not find any dishonesty. They essentially said how much they had to drink and went through the process. And so it's gone both ways, but it's been pretty much due to the facts of each case.
Thank you. That's helpful.
I think I'll add to the record, just kind of a starting point. In this case, there is a lot of mitigation, and there's been a lot of discussion about things after the incident, and those are all, I think, going in a very positive direction. So based off of the mitigation stated, today's testimony, I'm leaning towards the lower end or the bottom end of our scale today, and looking at 3 years.
Lofgren, for the record, yeah, based on the treatment that he has gone through and the number of letters of support and recommendation, I would agree with the very shortest amount of time.
Their discussion for the record.
Brian Hughes for the record. I agree after hearing how the committee has previously handled these and after the discussion today and some of the issues I've raised with taking accountability, actually working a program and doing more, in my opinion, more than the typical diversion things require. I would lean towards the lower end on this case.
Keep looking for a motion in a second on the amount of time.
I think I'll make a motion to impose 3-year ineligibility period.
Warren,
Brian
Can I
Hughes, I'll
second
second.
that?
We are voting on a motion for a 3-year ineligibility period. Chair Downing,
Aye.
Vice Chair Cotting.
Aye.
Committee Member Sarek,
Aye.
Committee Member Hughes,
Aye.
Committee Member Hensman,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
and Committee Member Willetts. Motion passed.
Take a quick 5-minute break. Let's take a 5-minute break. 7 minutes, something like that. Let's go 7 minutes.
6.5.
Okay, the Police Policy Committee is resuming at 11:18 hours, and so we're ready for our next case.
Yes.
Seeing a lot of stuff today. Here's my paper. Good morning. Thank you for being here. My name is Scotty Nowing. I'm the chair of the Police Policy Committee. We'll begin your case by first hearing a case summary from DPSST. Then I'll give you further instructions before you begin your statement.
Mr. Chair, Melissa Langbatra for the record. The department opened a professional standards case to review Matthew Walker's separation from the Cottage Grove Police Department on October 18th, 2023. Walker was initially terminated after an investigation found that he had improperly detained a woman in the city jail after her release was ordered by a judge, failed to take appropriate legal action against individuals who drove from the agency's Christmas party to the police station while displaying signs of intoxication, and brought department-owned weapons to his home, including 2 automatic machine guns, which he used while off-duty for personal reasons, and allowed friends and family and other civilians to operate the department weapons. Walker agreed his termination, which was overturned, restoring him to employment with a demotion from a sergeant to a police officer. The arbitrator made findings related to Walker's conduct in each of the incidents, finding in the gun incident that there was insufficient information that Walker violated state or federal law. Arbitrator did find that there was sufficient evidence that Walker violated agency policies related to his improperly detaining a woman after her release was ordered by a judge, and for failing to take appropriate action when he knew partygoers had driven to the police station while intoxicated. The department reviewed the information and identified moral fitness violations in the record based on Walker's separation. The department found misuse of authority. The Walker intentionally used his position as an armorer, which gave him access to machine and submachine guns to obtain a benefit. Used access to machine guns and submachine guns and allowed members of the public to use the firearms for non-official purposes for the benefit of the members of the public. Walker intentionally used intoxilizer equipment for non-official use for the benefit of another. Walker harmed a person when he held a woman in custody after a judge ordered her to be released from custody. And Walker threatened persons or property by failing to make an arrest of a man who drove to the police station while intoxicated. The department is seeking a disposition in the case from the committee, and Walker provided written mitigation, which was provided to the committee, and he's here today to give a verbal statement, Mr. Chair.
Thank you. You will have 5 minutes to share any information you would like the committee members to consider during the deliberation of your case. Your time will be monitored on the clock, to be right on your left side. And at the conclusion of your statement, you may choose to remain in the room, but you will not be permitted to ask any questions or provide additional comments for this case. Whenever you're ready.
Thank you. Morning, committee members. Members of the board, you reviewed the facts and evidence regarding the past. Now I want to take the time to talk to you about the officer that's sitting in front of you today. Following a period of deep self-reflection, I have chosen the only honorable path to take, which is full accountability for my actions. This is including accepting the discipline that was handed down to me, including my demotion from a patrol sergeant to a patrol officer. And I've committed to moving forward with absolute professionalism on the job.
Returning to duty last April, for me personally, was very daunting. I walked into a reshaped police department under complete new leadership, surrounded by a wave of new and mostly inexperienced officers. Under the current leadership of Chief Chase, I have found exactly what I needed to succeed in the structure, clear expectations, and unwavering support that I've received. For the past 16 months, I have reported to duty each day with humility, focus, and a dedication to teamwork. I have worked tirelessly to mirror the leadership and mindset that is being molded by Chief Chase, Captain Pastor, our patrol captain, and the patrol sergeants that I work under. This mentorship has fundamentally changed how I view my role, helping me become a better officer for my peers and a better servant to our citizens. I have worked my way back to being a valued and trusted field training officer and mentor to our younger officers. Chief Chase sits with me here today to show his support and the work that I've put forward, and I'm profoundly grateful for the opportunity he has given me to continue serving in this capacity. I still have a vast amount of value to offer this department and our community. I have 5 years of reserve officer experience and then 12 years as a full-time police officer. I respectfully request that the board consider the full context of my growth, the letters of support that you've been supplied with, and my recent service before making your decision. I thank you for your time today.
Thank you. Please adopt the record as presented. Be by a thumbs up consensus. Here's we do have a consensus. Record will be adopted. We'll now move to discussion of aggravating or mitigating factors. Reminder to state your name for the record and identify if your point is aggravating or mitigating.
Brian Hughes for the record. Mitigating factor for me, and I think the record is explicitly clear that the Cottage Grove Police Department was facing significant challenges in its executive leadership at the time, and that Sergeant Walker, then Sergeant Walker, worked his career, most of his career, with that executive leadership, and that it was found to be in such disarray, I guess, to put it lightly, I think mitigates some of that. Sergeant Walker, in a position of leadership himself as a sergeant, certainly should be, making a better, what I'm trying to say here, conducting himself to a higher standard, especially in a position of leadership. But when all the examples ahead of him were challenged themselves, I think that made it difficult for him to be successful in his role as a sergeant. So I find that to be a mitigating factor.
Thank you. Scott Downing for the record. I also find mitigating his letters of support, the fact that his chief is here supporting him today. And I mirror what Chief Hughes said. There was multiple points in this record where people who had evaluated this entire case were struck by how much inaccuracies in policy and procedures. Didn't seem like they knew if their jail wasn't accredited, and no one seemed to know it. How long could they? No one really knew how long they could keep someone in the jail, and it just seemed like this information was kind of passed down through the ranks to be true, when it absolutely wasn't. And then at some point, it comes to a head, and unfortunately, it was with this sergeant.
Sam Ellis for the record. I'll echo both of your points. I think what was really telling to me was in Chief Chase's letter, there's a paragraph in the middle specifically outlaying how much chaos was in their department before he took over leadership, and how he says in there that this should not be held against Officer Walker wholly, and I tend to agree with that.
Their discussion, aggravating or mitigating factors.
Warren Hensman, for the record. Something mitigating that struck me, although technically inappropriate, conducting professional work off duty. He seemed committed with just taking care of business if he needed to fix somebody's rifle, gun, the armory thing at his house, struck me as quite odd also, but he was willing to do what he needed to do to support his organization. So I think that's important to reference as, mitigating.
Anyone else? Okay, Melissa.
Thank you, Chair. Melissa Batch for the record. I heard mitigating factors. The Cottage Grove Police Department was facing significant challenges in their leadership at the time. The entire time that Walker worked there was under leadership that was in disarray. The leadership examples that were available to him made it difficult for him to be exemplary in his role as a police officer. There was agreement that the agency that Walker was working at was in disarray, and information at the agency was passed down to him instead of being clearly laid out. The agency dysfunction shouldn't be on Walker wholly, and his professional work while off duty, he was willing to do what needed to be done to support the mission of the agency. Did I get all that?
For a consensus that you captured all of the mitigation?
Livingston for record really quick, sorry.
No, you're good.
Did you mention, and I missed it, but the letters of support, mitigation for letters of support and the chief being here today?
I didn't, thank you.
Now consensus? Like we have a consensus. We'll now begin deliberations regarding the moral fitness violation categories identified in the staff report, which we have no dishonesty, misuse of authority, and misconduct are the two. And we'll be looking for a vote to affirm, modify, or negate the violations alleged, and begin discussion on those.
Livingston for the record. After like taking it all into consideration, and while odd, some of the behavior and things don't maybe necessarily align with some of our other agencies and our expectations and rules and policies and all of that. Kind of all that it's mentioned that he was doing may have been or appeared to be or felt like that was acceptable in his agency at the time with the leadership and how they were functioning. So I struggle with the misuse of authority one, just because even though it seems odd to us and we wouldn't maybe necessarily do it in some of our own agencies, I don't know that he would have equated it in that way at the time.
Samuel, let's all follow on that. When looking through specifically the mitigation letter sent from the FOP, there were several quotes in there under each incident where it seemed like, specifically talking about the guns, it seemed like the chief knew that he was taking it out at times. The intoxilizer incident was addressed by the chief and the captain. And then the jail incident seemed like there was a mix of command staff that were involved in making that decision, and nobody really could pinpoint whose decision it was. It seemed like it passed along each of the sergeants and the captain himself. So I don't think we can fully lay that on Officer Walker's shoulders.
Other discussion? We haven't discussed failing to make an arrest of a person who drove to the police station. We haven't discussed maybe letting others use the machine guns. We should have some discussion on the record about those issues.
Brian Hughes for the record. I'll also refer to the FOP letter where, what it's really getting at is a culture, right? It's a lack of adhering to policies and procedures that are normalized for many of us in our departments. But when you don't have that, culture can move in and take over. And it's really highlighted in this kind of concept about being able to hold somebody for 3 days, right? There's nothing in there that anybody was able to find in any case law or anything else that said you can hold somebody for up to 72 hours for no reason. That is a clear indication of the culture here. So I think if we apply that to these other things like the machine guns and taking things home, with the chief being aware that that's a cultural, potentially a cultural norm here, I think that I have a challenge. I'm challenged to find that to be a misuse of authority when that's the culture that existed at Cottage Grove Police Department at the time, up to the chiefs that were at the helm. So I have a hard time with that. And then the everyone going to the police station and taking turns at blowing on the machine. I would try to find in the record here where it showed that there was a blow that maybe indicated somebody was impaired, and I had a hard time finding that piece, or if it was just that there was information that the person was impaired. But that presents, I think, some challenges there. It's a jail blow. People are there. And I agree, they're using the intoxilizer inappropriately. There's very clear direction on not using the intoxilizer that way, whether that's for some sort of a benefit, I don't believe. I think that they're using it here to take a look to see how intoxicated people are. I don't think that was good judgment, and I don't think they should have done that. And clearly, Sergeant Walker didn't either. The record shows that he was displeased that this had been presented to him at the PD at that time of day. He did report it to the chief of police and was counseled on that. And I think at the time he made that decision. I don't find that to be misconduct. Certainly, there's a level of discretion that comes with the job, and in this case, I just didn't find it to rise to that level.
Yeah, I'm inclined to not find the misuse of authority because he was doing, I think, what the agency he grew up in allowed. And if he hadn't been to another agency or saw how strict policies are in an agency that actually holds itself accountable, like I think someone else, things don't get tighter, they get looser and looser and looser until finally it comes to a head. And it seems like it came to a head with this individual. And thank goodness, it seems like the police department has done a full recalibration since then. So I would make a motion to negate misuse of authority, affirm misconduct.
Samuel, for the record, can we talk about why you want to affirm misconduct?
Well, I do think there's things in here he's doing wrong that probably anyone should know is wrong. I mean, I think the further discussion will be on one of the next steps is what do we do about it, or do we do something about it? But I think to say that he didn't have any misconduct is, and I think that clearly even the arbiter found he had misconduct because he returned the job but did demote him. So it wasn't that they said, hey, you're free and clear of everything. He does have some personal responsibility here, which I think falls in misconduct. Anyone who gets trained on an intoxilizer, we know you can't just have all your buddies come down and blow into them intoxilizer. And there's multiple things here. You can't have your friends shoot your apartment weapons. I guess if you have permission, maybe you can, but I think the taxpayers wouldn't probably appreciate it. And I think that as officers, we should know that. So I do find there was misconduct. I agree with the arbiter more of he was disciplined. Took a demotion.
Brian Hughes for the record. I could be convinced there on the use of the intoxilizer. It's a piece of equipment I've used my entire career. Very familiar that it's not to be used for these situations, and ultimately could jeopardize the department's use of that machine. And so, and as the arbitrator did state, there was conduct that justified the demotion. to officer from sergeant. So I believe misconduct would have occurred with regards to the intoxilizer.
I think similar to the last case, we have to look at the facts presented. Is this misconduct or is it not? And whether there's mitigating factors in that misconduct or there's other reasons for the misconduct. There was misconduct at least in my reading of all the evidence. And then our next step will be, what are we going to do about it? Or if anything, as far as this person's certification.
Warren Hensman for the record, just to continue the conversation regarding the misconduct piece. And we can't forget that there was a person held for a couple of days at their facility. And ultimately, I believe I read the charge wasn't even filed. And there was a lot of discussion that went on as to the 72-hour hold. And if it was so important to me, why wasn't there a PC statement scratched out immediately? It didn't make a lot of sense. It almost, I'm not going to make any suggestions, but just something did not feel right. And I don't think we can negate the fact that there was somebody held when they didn't need to be. Should have been scooped up, taken to the Lane County Jail, and then we're done.
So I'll redo my motion. I make a motion to negate misuse of authority and affirm misconduct. We're looking for a second or more discussion.
Warren Hensman, I'd second that.
Right, we are voting on a motion to modify the moral fitness violations to remove misuse of authority and affirm misconduct. Chair Nowning,
Aye.
Vice Chair Cotting,
Aye.
Committee Member Sarek.
Aye.
Committee Member Hughes,
Aye.
Committee Member Hensman,
Aye.
Committee Member Livingston. Aye. Committee Member Lofgren. Aye. And Committee Member Wiltz. Motion passed.
Okay, now we'll be looking for a motion and a second to take action or take no action. Please state your name for the record and your supporting reasons for taking action or taking no action. Scotty Nowning for the record, I think for all the reasons we talked about before, the culture, all of the disarray this agency was in, the fact that he has gone through, I wouldn't say he got away with his misconduct because he did go through a termination and getting his job back and then a demotion. And now since before us, working his way back into the career, I'm leaning toward taking no action.
Warren
Member
Hensman.
Lofgren, I second that.
Oh, I haven't made a motion yet, but I'm seconding me.
Okay.
Go ahead.
Thank you, Warren Hensman. I think it's important, and I agree to negate. What struck me is during the opportunity to speak and when he mentioned mirror the leadership, we all need to be able to mirror what's right. And that's what builds a strong culture over years and years and years. So that was well said for me. I just wanted to get that on the record.
I'll kind of echo that. And then to Deputy Chief Hughes's point for earlier, he's come back into this career and he's made it a point to be a mentor and be a leader and be a trainer. And I think that speaks volumes, especially going from having the humility to go from a sergeant, from a supervisor to an officer, and then be surrounded with a bunch of inexperienced officers. I think that speaks volumes. So with that, I will make a motion that we take no action on the misconduct.
Lofgren, now I second it.
All right, we are voting on a motion to take no action. Chair Nowning.
Aye.
Vice Chair Cotting.
Aye.
Committee Member Sarek.
Aye.
Committee Member Hughes.
Aye.
Committee Member Hensman.
Aye.
Committee Member Livingston. Aye. Committee Member Lofgren. Aye. And Committee Member Wiltz. Motion passed.
Thank you. Yep, 7 and
So he's still up. Important.
we're getting rid of number 7 on our agenda, unfortunately, and number 9, unfortunately. Wait, you said unless there was no.
She's just doing 8.
No, just doing it. Gotcha. We're doing 8.
Okay. So if you all have tabled 7, the approval of the changes to the basic police curriculum, then I request tabling 8, the changes to the rule 025900800085, because that was the board's approval of the changes to the curriculum. And then that would be me presenting and the proposed rule changes for Oregon Administrative Rules 25900800005, 290, 300, 310, 320, 330, 340, and 100.
So we'll table 7, 8, and 9. Okay.
So speaking to that wonderful collection of administrative rules that are listed in number 10. These are our moral fitness rule changes that you all have been listening to since February. Excuse me, Jennifer Howell for the record. In February, the Telecommunications Policy Committee, the Corrections Policy Committee, and the Police Policy Committee began reviewing draft rule changes for moral fitness standards and denial and revocation processes. The rule changes were based on recommendations developed by staff in consultation with the Moral Fitness Work Group. In May, the 3 committees reviewed public comment from the first draft of the proposed rule changes and 2 new rule changes that were presented to the May policy committees. Now, during the August committees, the 3 committees will review the revised draft rule changes. The revisions to the rules include the committee comments that were collected in February, the committee review of public comment in May, merging the 2 rules that were presented in May with the full rule package, and DPSST review of the public comments that were received for the arbitration rule changes that were presented in May. The complete set of the revised rule changes is included in your packet as attachment A. Your memo includes a summary of all of the revisions that were made. In today's presentation, I'm going to focus on the moral fitness category definitions and the terms harm and emotional suffering, the emergency suspension, the ineligibility period minimums, and the public comment and recommended changes for arbitration. However, you're invited to discuss or ask questions on any part of the revised rule changes in their entirety, whether it was amended or not. Turning to attachment A. First, I'd like to note that the parts of the rule that were revised were shaded for ease of review as you went through those 30 pages. Okay, so looking at the definitions rule 259008005, the moral fitness category misconduct and the pre-employment category gross misconduct include conduct that caused or could cause harm. In the initial rule changes, we included adoption of the definition for harm. When reviewing the definition of harm during the work group and the February policy committees, there was discussion on how to recognize misconduct may include emotional harm, while on the other hand, ensuring that the definition wasn't too objective or too subjective or too broad. The revised rule changes address this issue through the following changes. When you look at number 23, the definition of harm, we removed the line that included emotional distress and instead replaced that with a new definition, section 19, emotional suffering. This replacement constitutes harm and emotional suffering under the context of a moral fitness violation. So as shown there in the definition, emotional suffering means significant emotional or psychological distress that a reasonable person would experience as a result of conduct such as, but not limited to, stalking, menacing, harassment, humiliation, or other similar behavior. So then when you look back to gross misconduct and misconduct, definitions 22 and 32, these were revised to further limit the potential subjectivity. And the revisions change the phrase conduct that causes or could cause harm to break it out separately. Conduct that causes harm, could cause harm, or caused emotional suffering. For emotional suffering to be identified as part of the misconduct, the findings in the professional standards case would need to show that the conduct caused emotional suffering. We also included in the definition of misuse of authority, that separate phrase for emotional suffering for consistency across all of the terminology uses of harm. The next item was emergency suspension. So if you turned to pages 17 and 18 of attachment A, this is Rule 259-008-0300, Section 6. Emergency suspension was rewritten to narrow the scope of the initially proposed language to issue emergency suspensions based on being charged with a felony. This was a significant committee discussion in both February and May. The discussions focused on avoiding overly broad emergency suspension authority. The revised rule changes, you'll see that we maintain the current requirements for the department to issue an emergency suspension order if the policy committee, the board, or the board's executive committee find there is a serious danger to public safety. If the revisions are approved, the new language would provide some context for what the board considers to be danger to public safety. As revised, that would include a public safety professional charged with a Measure 11 crime while their criminal case is pending, and a public safety professional whose conduct is there's a pending mandatory or discretionary revocation in process, and their continued certification and ability to perform the duties of office would be a danger to the public or an erosion of public trust. Prior to any emergency suspension, the matter would have to be considered by a policy committee, the board, or the executive committee. The department would not have any independent discretion or authority to issue an emergency suspension order. The next item for review are the ineligibility periods. Those are on pages 21 and 22. Under your current administrative rules, the ineligibility period following a denial or revocation ranges from 3 to 10 years for misconduct and misuse of authority, and 3 years to lifetime for dishonesty and discriminatory conduct. In the initial draft rule changes shared in February, the changes would have reduced the minimum ineligibility period options to 0 days across all of the moral fitness categories. The changes to the minimum ineligibility period were proposed to address cases when the committee found that the conduct rose to the level to take action, but chose not to take action because the 3-year minimum ineligibility period was too harsh based on the committee's consideration of mitigating factors. So after committee feedback, this section of Administrative Rule 259-008-0310, Section 10, B.D. was revised to change the minimum ineligibility periods for dishonesty, misuse of authority, and misconduct involving discriminatory conduct to a minimum of 1 year, in recognition that these violations were egregious on their own to require at least 1 year to pass following denial or revocation before a person could reapply for certification. The 0 days of ineligibility will still be included as an option for misconduct when there are no other moral fitness violations. The next section is arbitration. The last area I wanted to cover in depth was the arbitration process, which is found in Administrative Rule 259-008-310, Section 8 on pages 19 through 20. In May, the department submitted a proposed rule change to remove the current process for reviewing a professional standards case after an employment arbitration and replace it with language asserting the department and board authority to review the conduct and make moral fitness findings regardless of the outcome of the arbitration. The committees supported those proposed rule changes, but because public comment raised substantive issues, this section is included today to ensure that you have the opportunity to review and consider the comments and the recommended rule revisions. The written comment on the proposed rule change was included in your packet as attachment B. The comment asserts that the existing rule governing DPSST's use of arbitration findings strikes an appropriate and functional balance between collective bargaining employment standards and board certification requirements, emphasizing that both systems regulate substantially overlapping conduct and traditionally operate in a symbiotic relationship. The commenter opposed removing the current rule structure, asserting that doing so could allow the department to disregard conclusive arbitration outcomes, rely on hearsay evidence, and potentially decertify a public safety professional based on facts that an arbitrator found insufficient. The commenter also emphasized that such changes could undermine due process protections, weaken the finality of binding arbitration, and conflict with the principles of collective bargaining. The department carefully reviewed the commenter's concerns, particularly concerns about due process and the relationship between employer findings and the department's certification responsibilities. The department has a statutory and regulatory obligation to independently assess whether conduct constitutes a violation of the board's moral fitness standards, even when that same conduct does not meet the employer's definition of misconduct under a collective bargaining agreement. Failing to review the conduct under the discretionary moral fitness process risks undermining confidence in the board's standards and the department's commitment to accountability. To address both the department's concerns and the public comment concerns, subsection 8 was revised to restore that conditional deference to arbitrator findings while still preserving the department and board independent authority to review moral fitness violations. The revised language maintains the practice of recommending administrative closure when the arbitrator finds that the underlying facts do not support the employer's allegations of misconduct. However, there are clarifying changes. These include replacing will recommend administrative closure with may recommend administrative closure, allowing the case to proceed as originally proposed when substantial evidence that a moral fitness violation exists, and as currently written when new information is discovered that was not available during arbitration. These revisions provide alignment with the department's stated goals and a clear framework for how employment arbitration interacts with the professional standards case processes. They will help ensure that the department will continue to consider arbitration findings thoughtfully without relinquishing its responsibility to enforce moral fitness expectations. The department's recommended revisions have been inserted into that revised rule text. They're on pages 19 through 20. Those were all of my prepared remarks for covering. However, I do want to make sure that the committee has an opportunity to ask any questions about what was presented today or any of the material that's in attachment A.
Will, Scott Downey for the record. So I saw the public comment from Public Safety Labor Group. Will they have a chance to see your reaction to their suggestions and say, and do another comment like, oh, that closes the gap for us, or we feel better about that? Or, I mean, I thought they made some good arguments. Some of it I understand, but a lot of legalese in there, but.
Under our current process plan, thank you, Jennifer Howell, for the record. Our current process plan was to have it reviewed by the committees. And if the committees found that it was an appropriate change, the change shows that the agency considered the comment and the committees and the board considered the comment and made adjustments accordingly. And if the board approves, then we would proceed on to the permanent rulemaking. So we did not have plans to resubmit it for additional proposed public comment period. So we have the presentations to each of the policy committees that the commenter can review as a member of the public, as well as we have it posted on our rulemaking website. The proposed changes.
I mean, I only say because the public comment came from an organization that represents a lot of police officers in the state and deals with a lot of arbitration. So I do think that their comment held weight for me of these are folks who are doing this every day. And so know much more about it than I do for sure. So.
Marie Atwood for the record. I also think it's important to note that our the revisions that we've made in light of the public comment have also been posted publicly as a response to the public comment. So it's not that those are just existing in the vacuum of this discussion. The commenters also have access to that information and can see that we've responded accordingly based on the concerns and issues that they raised.
Okay, but there's not a mechanism for them to comment back and say, looks good, or.
There's not a formal process for that unless the department resubmits the proposed rule change.
I mean, it seems like a significant rule change to, I mean, if you have the group that represents the bulk of officers concerned about it, I don't know what that looks like to resubmit, but this seems like something we have to get right.
Yeah. Jennifer Howell for the record. Yes, with if the policy committee recommends it, the agency can resubmit specifically this administrative rule and this change as a new proposed rule change with the new language.
And then there will be a new public comment period.
A new public comment period. It could be done and processed prior to the board meeting, but we wouldn't know whether or not we received comments until after board materials were published. So we'd have to do verbal updates to the board as to the outcome.
I think it's worth it because you're dealing with collective bargaining agreements, you're dealing with arbitration decisions, you're dealing with, I mean, this is a big rule change. Yes, sir.
Mr. Chair, if I could.
You may.
Phil Castle for the record. So I'd like to give a little bit of context and then a little bit of history. So when this whole thing came up, I did some research on where this rule came from. This rule for me sticks out. An arbiter's decision can block DPSST's processes. The same is not true for an ALJ. An administrative law judge does not have the same authority to block a process. And I was wondering, why was there such a disparity there with an arbiter? So in 2006, there was, I'm not going to get into names, but there was a law enforcement official who publicly stated, and I have the article here right in front of me, who publicly stated that DPSST would handle this situation basically for him. I'll sum it up. And that DPSST, he's requesting that DPSST take a certification of an officer who an arbiter had turned over their case. So one time back in 2006, this occurred. There was obviously a lot of people upset about that for good reason. That was an inappropriate thing to ask. And that's where the board rule came from. It came from that particular article. It went right to the board subsequently after. There's board history of showing that. And I want to state this for the record for the public to understand. There are 3 sets of laws or rules that govern a law enforcement officer's career. One, there's the color of law in which they serve under, which their authorities, their policies, and criminal law tied together. Number 2, there's employment law. Employment law covers and governs an officer's career. Number 3 is licensure. Licensure, and it's separate and governed separately for a reason. This particular rule for me, I'm offering my opinion on how I viewed this in comparison with an ALJ and the ALJ's authority in this circumstance, is not appropriate. And it blocks us from assessing moral fitness. We are not assessing employment. That is not our purview. We are assessing moral fitness. This particular rule blocks that. This turning will to may allows us to pursue a moral fitness violation and still consider the arbiter's ruling, right? But it doesn't block us from pursuing the moral fitness, which is associated with licensure, not necessarily employment. I do understand there is a connection that you must have a license in order to be employed. However, we must preserve this board's ability to assess moral fitness, and it cannot be blocked by another section of what governs a law enforcement officer's career. Thanks for the time.
Thank you. I do understand that, but I also think it would be naive to sit here and think if an agency lost an arbitration that they wouldn't say, we've got this other, and how many times would the officer have to keep winning their job back essentially? And at some point, when is it to the point where it's unfair, where it's insurmountable odds, essentially, even when folks are ruling in your favor. So let's say an agency uses misconduct of its own policies to investigate an officer. And so an arbiter says, you did all sorts of things that are in violation of the collective bargaining agreement. None of this was fair. We're giving this officer the job back. You're like, well, we're going to check on it. And we don't really care that they used unfair means to do that. That's not really what we're worried about. So I think that's my concern is how even will the playing field be for a person who's accused. And I think that, we know we see it when an officer has done something that needs to be handled. And I think this this committee particularly has handled it a lot. So.
Maria, for the record, I see your perspective. I would just want to kind of build off of what Director Castle was stating, is that this is an issue where the rule makes it unclear, as currently written, where each different branch's jurisdiction begins and ends. Although they are interrelated, as it is being interpreted currently, the vagueness of the wording of this rule is stripping DPSST, this committee, and our board from being able to even consider whether a moral fitness violation may have been committed in light of perhaps a procedural problem that occurred with an employment action. Our moral fitness violations are a totally separate set of rules, totally different consideration of statutes than employment law. This would be similar to if someone gets arrested for a crime, let's say damage done during a vehicular crash, DUI maybe. And that person gets charged with a DUI, but something procedurally incorrect happened during the investigation, or a witness is unavailable and the crime gets dismissed in criminal court. The victim who is hurt during the course of that criminal conduct could still file a civil lawsuit because it's a different set of rules. It's a different set of statutes and standards and different jurisdictional body deciding whether or not civil law was violated. And that way that person can still be made whole to an extent. Those branches are interrelated. They're always going to impact each other. But a criminal law can't take away someone's civil rights and abilities to file a cause of action. We would never allow a law to be framed in a way that deprived those independent jurisdictions of their authority. So in that sense, this rule is causing a conflict in the sense that it is stripping DPSST's administrative authority on the basis of employment law jurisdiction, which is not our purview. And our jurisdiction is not their purview.
Right. So we don't want to downplay the interconnectedness of it because ultimately DPSST holds the cards. Because if you don't have a certification, you're not a police officer, no matter what. So this is, I mean, you are really, you said it's these three things. It's really certification up here. Because without certification, the other things don't exist. So that's why I think this is so important to get correct. And I'm not saying I have the right answer, but in reading the public comment, it certainly caused me to. There were some very valid points made in there where there's a conflict between a lot of competing interests. And so I just think we have to get it right.
Sam Ellis for the record, I'm going to echo the chair's point. I think that I don't think there's any disagreement in the fact that this rule needs to be clarified, but I think and correct me if I'm wrong, what we're asking for is that it gets resubmitted for public comment just to get the commenter's opinion, so to speak, of what the change was to it. Because there is some very valid points in that. And as the chair very adequately said, without certification, you don't have a job.
Connie, for the record, I'll just add my 2 cents is that it's changing it to a may. And we have seen and will continue to see, I think, cases where an arbiter may weigh in, yet we have still found misconduct and moral fitness violations. So I hear you, like, an individual will have to defend their actions and what they did or didn't do, in various, phases, criminally first, but oftentimes a DA will decide for a lot of different reasons to not file charges against an individual. Doesn't mean a crime did not occur. And so you water that all the way down to this body that needs to examine whether or not an individual should have licensure to be a police officer in this state. I think it's, if there's question, they should come in and present the facts and let us weigh in on that. So it gives us that opportunity.
Livingston, for the record, I think today's a great example of how this board can act appropriately and take in the information and come to a conclusion that seems fair. And even though they have to come back in and talk about it again, it's still, the process is there and works itself out. And I would hate for DPSST to continue to be blocked from that ability to do that just because of a technicality and maybe a process that wasn't handled correctly. Because not every agency in the state has the same capability and experience to manage cases, which is why we have contracts and labor law and all that. But I do agree that they're separate and they have a different purpose.
And I think that's more my concern. I think some of the agencies who deal with discipline issues and deal with collective bargaining issues, and that on a daily basis, and they have folks who deal with it all the time, are very good at it. They're very cautious. They have a legal department. They're very cautious about not violating collective bargaining agreements, doing things that are fair. And then you have agencies who just don't deal with it. And so when they do deal with it, they don't always do the right thing, not even intentionally, but so. I just think, like, I would love to hear additional public comment after the changes are made. That's from one person, so. I don't see the harm in it. I think it's such an important issue, and I'm not trying to hamstring anything this committee does, because I do think it's really important. Makeup of the committee will change. Policies and chiefs and sheriffs and everyone will change, and so it's a constant, your policies have to be able to withstand all of those changes. And any people who sit in this room are going to have to be able to withstand those changes, so.
One more comment, if it's okay, Mr. Chair.
Of course.
And respectfully, Phil Castle, for the record. I may appear to anchor to this one, but it's my role as the secretary of this board, and also Marie's role, to get these cases in front of this board and policy committee for consideration. And anything that blocks that, in our opinion, or that's inappropriate, I'm gonna be taking a hard look at. For this committee, I would look at recent history and recent cases that we've processed that have been under similar conditions, and we have done so appropriately. And in my mind and my knowledge, this committee, nor has the board, been used inappropriately to affect any outcomes that would be unfair to any particular officer or law enforcement official. And with that, if it is the will of the policy committee and the board that this go back out to comment, we will absolutely comply.
Maria, for the record, just to jump off of that, procedurally speaking, I do just want to make sure the committee knows that kind of restarting that clock could result in a potentially massive delay in getting any sort of finalized rule pushed forward. I mean, you've seen, it's been since February that we've been going kind of around in circles, talking, changing, rediscussing, re-revising. And even before that, we've been working on this moral fitness rules change project for over 2 years. It's been a very long time to get to this point, which is hopefully, at least the vast majority of these rule changes will be going to our October board for finalization. Candidly, there's always going to be some public comment to most of the rule changes that we propose, especially if they involve our moral fitness standards. And when rule change comments come through from entities or individuals that clearly have a stake in their outcome and are essentially saying, don't change it. What I don't want is for our committees and our board to get into an endless cycle of waiting for public approval of everything we're trying to do, when it's our jurisdiction and your decision-making that we're trying to make more precise, stronger, and better for the general public.
Certainly, by your own admission, you did make some changes based on this public comment, presumably because they were valid points. And so my only point in this whole thing, and I don't know the right answer, and maybe the right answer is somewhere in between, but my only point in this whole thing was, what do the folks who made that public comment that caused you to change some of their things, what do they say about that? And if there's not a mechanism, I wish I could just call them right now and say, hey, what do you think? And we could have a debate, but that's not how this works. So we have to open it back up. And so I was on the Moral Fitness Committee for 2 years. I understand it was the meetings, and there was healthy discussion about a lot of issues because these are really important things. So the fact that it may take a little bit longer doesn't necessarily move the needle for me to get it right. I think to get it right, we need to get it right. And so that's the mechanism we're stuck with is to put it back out for public comment. I wish there was a more efficient way. But it doesn't seem like there is. So.
Brian Hughes for the record. If I could just highlight that the attachment B is here in my materials, and I was able to read it and inform my decision today. And I just want to echo what Superintendent Cotting said. I have only been on 2 of these now, and very clearly see the value in having that language changed to may hear a case regardless of an arbitrator's ruling, and see the value and importance in that, to where other aspects of the process have deemed not to move forward, we'll call it that, but yet there is some underlying conduct that needs to be addressed. And I believe that this committee did that work. I was here working my way through it and saw the value in reviewing that regardless. So I don't know that that needs to go back out for public comment when I can review and make my decision based on what I'm reading here today.
Thank you. So how do we find out if it goes back up for public comment? Do we make a motion?
It's a good question.
Who knows the answer to that?
Jennifer, do you want to take this one or you want me to try?
Certainly. Let's see.
I can take a stab at it.
Well, I'm just trying to figure out where to start. So what would the next steps be if going back out for public comment weren't what you wanted to do? The next steps forward are that the department recommends approval of the rule changes that are presented in attachment A. If TPC, CPC, and PPC approve these rule changes, then they'll be submitted to the board in October for final approval to become permanent rules. That said, procedurally, it's still possible to redirect something back for public comment. If there's comment received, we could determine what that comment means to the next step of the process. And procedurally, as we presented this arbitration rule as a separate rule change in May, it could be withdrawn from the full package if need be for the October board.
Jennifer, we've already had policy committees approve this, correct?
Yes. The Corrections Policy Committee approved as is. The Telecommunications Policy Committee meets next week.
Okay. Wouldn't the next steps be then each policy committee makes a recommendation and then it goes in front of the board?
Yes.
And then the board ultimately approves, disapproves?
Correct.
Livingston for record. So basically, I'm just asking, like, we can either put a vote to say we want to vote to recommend approving the rules as is. Or if someone wanted to pose a motion to vote to send it back out because we don't want to approve it, like we're saying, we don't want to approve it at this time, we'd like it. And like, is that the two options we're looking at based on the conversations we're having?
Bring Atwood for the record. So I think there's a couple of there's maybe 3 different lanes. The committee could vote to approve the rules in their entirety as written, considering our response to the public comments already received and the changes we made in light of those comments. So the arbitration rule would be included in the overall package. You could approve the full package today. Option 2 would be this committee could vote to approve the package in its entirety minus the arbitration rule, in which case, if the committee requested that we resubmit the arbitration rule for public comment again, we would perform that process, receive any feedback, prepare another response to second round of public comment, draft a new memo, and bring it back to you again. I do think, and Jennifer, please correct me if I'm wrong, I think that if we were to make additional changes to the arbitration rule that the Corrections Policy Committee has already approved, we would have to go back to them again. So kind of overturn what they've already decided and come back to them with yet another version of that new rule. But that is option 2, approve everything else except the arbitration and kind of go back to the starting point with that one. Option 3, which no one's mentioned, but is theoretically possible, would be if the committee decides you don't want to approve any of the rules, you could deny the package in its entirety today. But it sounds like we're mainly discussing the difference between options 1 and 2.
So Livingston, so it would be appropriate if I wanted to, I could make an emotion that we approve it to include the changes, arbitration, like as it sits. I can make a motion to just approve it and then we can do a vote, see where we're at.
Yes.
I would like to make a motion to do that.
Brian Hughes, second the motion.
Right, we are voting on a motion to approve the revised rule changes for the OIRs listed. Chair Nowning,
Nay.
Vice Chair Cotting.
Aye.
Committee Member Sarek,
Aye.
Committee Member Hughes,
Aye.
Committee Member Hensman,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
and Committee Member Willis.
Nay.
Thank you.
That's it for that. Okay, agency updates.
Thank you, Mr. Chair. Bill Castle for the record again. First and foremost, just want to acknowledge the heavy day. This is a hard and heavy day, and I really appreciate your work that you put into being here, the commitment that you have to being here. It's not lost on the public, on us at all. So thank you so much for all the work that you do to be here. Also appreciate the really careful consideration and conversation. I appreciate the nay votes 100%. I do, because that's real consideration and not bandwagoning. It's your opinions, and they matter. Your voice matters here a lot. So just want to keep encouraging you to contribute that voice. And disagreement is good and healthy. That's why we have these boards and policies committees. So thank you for that very much. I also want to thank the staff, as always. So much work and preparation goes into this, and so much leadership goes into this as well. So thank you, Marie, for your leadership in this. But really appreciate the staff and all the work you put into and preparing this. Really very professional work. Lost a really, really important partner in this organization for me. Kathy McAlpine started her first day yesterday at the South Sound 911 call center. Talked to her last night. She's doing great. She gets home in 8 minutes now instead of 2 hours and 45 minutes. So really happy for her up there, but sure, missing her. And right now, the interim director or deputy director for the agency is Chris Inquist. He's filling in as an interim until Marcia Harnden, Chief Marcia Harnden from Albany. I'm still working on saying Albany. I get that. Yeah, I got that New Hampshire in me that wants to say Albany. But she'll be starting probably 1st of December. She'll be joining us. So very excited for Marcia to be joining us. Like every state agency, we're in the throes of our agency requested budget submission. We have just submitted that. And so far that's going very well. We are in the midst of our learning management system RFP, which is, it's taken us a long time to get to this point. It's a long process to go through RFP, but we're there. We're working really hard to get that thing out so we can see what vendors we will potentially be entertaining and likely have. Wanted to let everybody know that we have hired a new instructor development coordinator. Her name is Jennifer Moreno, very, very highly certified and credentialed instructor development person. And she's been here for a while. She's been an APT for us and now come on board full time with the goal of applying a lot more rigor to our instructor development. We will have a basic instructor development course that we'll be refielding. We'll have advanced instructor development. We will have venue specific instructor development, and we will be sharing all of it. So it won't just be for DPSST. We will open it up to all agencies to participate. We intend to ultimately bring it out regionally, offering our instructor development out in the region all across the state as we begin to field this. Instructor development is an exponential payoff. If you can deliver training better, it's not just the curriculum, it's how it's delivered. You have an exponential increase in retention. And that's what we're really looking to develop. So we're always trying to get better. We have plenty of room to get better. We always are looking at ourselves to try and see how we can improve. Accordingly, we are still going through and will be for quite some time going through our accreditation through the International Association of Directors of Law Enforcement Standards and Training. They are conducting an accreditation of us. We're doing our academy side first, which means basically all training. And then we'll be doing what they call and refer to as the post side next, which is basically the regulatory side or this side of the house with professional standards. And actually our Center for Policing Excellence makes up part of that. So we will accredit that part second. We are learning a lot as we go through this accreditation. We're finding some gaps. Fortunately, nothing major, but we are finding some small gaps that we are closing. So what's great about this accreditation process is it's not just about what's the end state on the certificate. It's about learning and closing gaps as you find them through the process and working with your peers across the nation. And that's been going really well. Our F building, which is our main street, is finally complete. For those that don't know, that building suffered some structural damage from wind shear. That building was designed only for an external wind shear. Our village is a very windy place and it has giant doors on both ends of the building and therefore it takes a lot of wind right through the center of it. And it caused some pretty massive structural damage on the inside to the point where we were worried about having to close that building. And it is a major training area for us. It provides a lot of context, a lot of space, a lot of covered space. So that work is finally completed and it looks like the inside of Jonah the Whale. There are all new ribs coming up the side of that building, steel ribs and gussets that are securing that building. And we were able to repair the roof on top of the building as well. So that is complete. We're back into full operation down in the village and that's really great for us. Pending your questions, I'm going to pass it over to Marie.
Yeah, thank you, Marie Atwood, for the record. I only have one real big update, and that is a new member of our team here in Professional Standards. Sitting a couple seats down from me, you will see JC Gamble. She is the new unit manager for our criminal justice program. So you'll be seeing her at all of our upcoming policy committees, our boards, and she will be a very important point person in leadership for how we handle our moral fitness cases. JC has a lengthy experience in state service, was a sergeant with the Department of Corrections, worked for the Inspector General's office and several other public boards and committees as a manager. So we're thrilled to have her as part of our staff. Her experience has lined her up perfectly to do this work. And I think that you'll all find her to be a really excellent agency partner to work with in the future. Yeah.
Thank you, Mr. Chair.
Thank you. Any questions? With that, we will adjourn the meeting. Our next Police Policy Committee meeting is November 19th, 10 a.m. The weather will not be as nice, guaranteed.